We thought Colorado was the most difficult case of the cases that we've had involving this attempt by some organizations. This particular one was by Crew, which is a group out of Washington, D.C., an election watchdog group, to remove President Trump from the ballot either for the primaries or the general election. They filed these in Colorado, Michigan, Minnesota, West Virginia, Oklahoma. We've had success in Oklahoma, Michigan, and Minnesota, but as I told you, I expected the case in Colorado to be the most difficult. The judge seemed hostile to our legal position. We had Jane Raskin, Ben Sisney, and a team from the ACLJ out there working up the trial. And I was not optimistic. I thought this was the one that was going to go to the Supreme Court of the United States. Well, I was wrong, I'm happy to say. Her decision was that the president is not, which we argued, and not an officer for the purposes of the 14th Amendment, Section 3's removal, which is, by the way, what a lot of legal scholars have said, too. In my mind, the case is dead. Now, are they going to appeal it? Yes, it'll go right to the Colorado, either Court of Appeals or the Supreme Court of College. I don't think it's going to fare any better there. We now set our sights on West Virginia and Virginia.
Yeah, and it is encouraging. Like you said, this judge, we did not have high hopes that she was going to rule in President Trump's favor, but she did, finding that they could not keep him off the ballot based on this 14th Amendment argument. So it is a very huge win, and the ACLJ was there arguing for this very outcome, and it's a success. It's a win.
Harry Hutchinson's joining us right now. Harry, let's talk about the ballot access cases. It was a constitutional case under the 14th Amendment, Section 3. The judge went out of her way to go after President Trump with the whole 100 pages of, hey, by the way, he incited basically an insurrection, but nevertheless, the amendment doesn't apply to him.
Absolutely. So I think it's clear that this was a victory. It was a victory for the American people. It was a victory for freedom of speech and for freedom of association. Nonetheless, it's important to remind listeners that the Colorado judge did try to put her thumb on the scale without authority to do so. She did this by claiming that President Trump engaged in an insurrection or rebellion against his own government. And I think that's nonsense on stilts. Number two, I think it's clear that she conflated two sections of Section 3 of the 14th Amendment of the Constitution by claiming that if he gave any assistance to any of the demonstrators on January the 6th, that in essence meant he basically assisted an insurrection or rebellion. Keep in mind, those are two separate and distinct sections in the constitutional amendment. So the first question is, did Trump engage in an insurrection or rebellion against his own government? Obviously, that didn't occur. Second, we had to ask whether Donald Trump gave aid and comfort to an enemy. And clearly, the demonstrators on January the 6th, whether you like them or not, were not enemies of the United States government. There was no war declared. And so, again, I think at the end of the day, the judge missed the boat.
My sense is that no matter if you're for Trump, against Trump, you don't want your choices taken away by a Secretary of State.
No, absolutely not. And that's the issue really that's at play here, is the 14th Amendment is not self-executing. You cannot have some random Secretary of State saying, in my opinion, I think that this presidential candidate has committed insurrection and therefore cannot be on the ballot. That is ridiculous. And like Harry said, it fails really on all three aspects of the 14th Amendment argument. It's good that this judge says he is not an officer of the court, but he has not committed insurrection. And even this judge cannot declare that he has committed insurrection. He's not been charged with that. He's not been convicted of that. So again, the fact that she took 102 pages to write about that kind of shows, again, like Harry said, her bias.
The judge could have saved herself some precious time in her life if she had adopted, I think, the smarter approach. But I also think this decision and its length, 102 pages, confirms her own bias. And so what she is really hoping for is some other jurisdiction that will overrule her analysis with respect to whether or not Donald Trump was indeed an officer within the meaning of the 14th Amendment. I certainly hope that doesn't happen. And certainly if you look at the prevailing view in each and every jurisdiction where we've litigated,
it seems that does not carry the day.
It will not carry the day.
It's very interesting that this judge found him responsible for insurrection, a charge of which, Harry, he has not faced in a federal court.
Absolutely. And the reason why he hasn't faced a charge, that is Donald Trump, is because there's no evidence in support of such a charge. It's also important to keep in mind that this judge, as Cece pointed out earlier, still believes that the 14th Amendment is self-executing. There's scant legal precedent in support of that particular conclusion. In addition, this particular judge rejected the Colorado Republican Party's argument that it had an unfettered right to put its candidate on the primary ballot. That is consistent with the First Amendment. So again, I think this particular judge was wrong and committed serious constitutional and jurisprudential errors, even though at the end of the day, she did reach the right conclusion.
Congratulations on the victory in Colorado. It's important for America. It's important for the conservative movement. It's noble and right. And the ACLJ is amazing when these important issues arise. So bless you and congrats to you and your team for that hard work.
Now we've got to fight in Virginia, West Virginia, and there'll be appeals in Colorado. But I'm very confident now that we're going to see victories in all these, which will be a total of 8 cases that we won. So that's great. Folks, we're going into the last basically 10 days here of our Faith and Freedom Drive for the month of November. We're ahead of where we were last year, but we're not ahead of where our goal is. So we want to keep the fight going here. The fight to free the Israeli hostages continues. But at home, we've had an amazing win for voting rights. As you know, we just talked about all of those. Tomorrow, we're filing in West Virginia. And our support for Israel continues. We're preparing for a massive series of meetings across Europe next month to defend the hostages. In order to meet these historic challenges, we need your support. We're in the last 10 days of our Faith and Freedom Drive. I encourage you to go to ACLJ.org, have your tax-deductible gifts double, dollar for dollar. You can do that today, ACLJ.org. And this is what I'd really like you to do if you're able. Become an ACLJ champion, which means whatever amount you donate or whatever amount you can designate, make it a monthly gift, automatically recurring. You can do it right on the website, ACLJ.org. Become a champion. That really helps us out going into next year.